National Moot Court competition of National Law Festival Sparkle 4.0 was conducted, where the problem was about legalizing sex work. The moot competition was judged by Honorable Justice Rajesh S. Patil, Honorable Justice Vijay Kumar A. Patil, and Professor Kushal Vibhute. They had judged the finals and had already enlightened all of our students with our speeches. The moot problem was drafted by Dr. Tanaya Kamlakar and our Honorable Principal, Professor Dinkar Gitte. Good afternoon to all. KLE College of Law extends their heartiest welcome to all the participants, students, and most of all our esteemed dignitaries. Mirza Ghalib wrote that pain transcends into its own cure. Similarly, the hard work put in by the delegates and the volunteers, the labor that they did, the pain that they endured, has transcended into a marvelous journey that all of us traveled together in the past 4 days. With these words, I would like to invite on the dais our faculty Ashwini ma'am for the welcome speech.
Good afternoon, everyone. A very warm welcome to the valedictory ceremony of Sparkle 4.0. It is indeed a pleasure to be present among the eager faces of the participants after 2 years of having virtual competitions. I am sure that the participants were as excited as us to participate in an offline event. This National Law Fest turned out to be a successful endeavor on our part, as we had over 31 teams participating in the moot court competition and 26 teams in the client counseling competition. We hosted over 150 participants who were judged by practicing advocates, senior counsels, partners of reputed law firms, senior professors, and experienced mooters. We sincerely hope that the event was an enriching experience for all the participants. Today, we have amongst us the doyens of legal profession, and I'm extremely grateful for this opportunity to welcome them along with the other dignitaries present here. I would like to extend a hearty welcome to our chief guest, Honorable Mr. Justice Abhay S.Oka, Judge, Supreme Court of India. We are very excited to have your presence amongst us today, Your Lordship. I request Dr. Prabhakar Kore, our beloved chairman of KLE Society, to felicitate his Lordship. Thank you, sir. I would now like to extend a warm welcome to our guest of honor, Honorable Mr. Justice Rajesh S. Patil, Judge, Bombay High Court. We are very grateful that you could be with us here today, Your Lordship. I request Chairman Sir to felicitate his Lordship. I would like to extend a heartfelt welcome to our guest of honor, Honorable Mr. Justice Vijay Kumar Patil, Judge, High Court of Karnataka. We are indebted to have your presence with us here today, Your Lordship. I once again request Chairman Sir to felicitate his Lordship. I would like to extend an earnest welcome to our guest of honor, Professor Dr. Kushal Vibhute, former director of Amity Law School, Amity University, Mumbai. We are thankful that you could be with us here today, sir. I now request our principal, Dinkar Gete sir, to felicitate our beloved chairman, Dr. Prabhakar Kore sir. I would now call upon Professor Dr. Mallikarjunaya, Principal, KLE Society's Law College, Bangalore, to welcome and facilitate our directors, Sri Mahantesh Kavatagimath and Sri Shankaranna Munavalli and Sri Sridhar Babu, Advocate of Karnataka High Court. I would like to extend a warm welcome to our beloved principal, Dinkar Gite sir. Sir, we are always thankful for your motivation and leadership. I would also like to extend a hearty and warm welcome to Professor Dr. Mallikarjunaya, Principal, KLE Society of Law, Bangalore, whose constant guidance has been the reason for the success of this event. I would like to welcome Sri Ganesh Kumar, Principal, Junior College, KLE, Navi Mumbai, Dr. Gansham Giri, Principal, Degree College, KLE, Navi Mumbai, and Sri Deepesh Pillai, Manager of KLE Institutes, Navi Mumbai. Thank you for all the help that you have extended to us. I would like to extend a warm welcome to all the faculty of KLE College of Law and KLE Junior College who have been working tirelessly for the success of this event. I would be failing in my duty if I do not welcome all the participants who have traveled from all over India to participate in this competition. They were truly the stars of the event. We hope that you had an enriching experience throughout the competition. Finally, I would like to also welcome my dear students and volunteers whose hard work and toil has been the backbone of this competition. Thank you all.
I would like to call on the dais Professor Navjot Kaur for the introduction of the dignitaries.
It gives me immense pleasure to introduce Dr. Prabhakar Kore, a multifaceted personality with significant contribution in education, agriculture, and healthcare, politics, and community welfare as well, making a mark on state, national, and international scenario. An individual whose life and efforts have been dedicated to transforming lives through education, healthcare, and research. Under Sir's leadership, KLE has grown from 38 institutions into an organization of global repute with 290 institutions and has made noteworthy contributions in each field. Sir has done immense contribution to the healthcare and community welfare. Sir has also contributed as a facilitator of international collaborations in education and research. Sir has completed his 75 years and all KLE institutions throughout the country celebrated it with full zeal and enthusiasm. Sir is a winner of several accolades, including honorary doctorates and other felicitations. for contributions of education, healthcare, research, and social work. Honorary doctorate conferred by Karnataka University, Dharwad in February 2008. Sir is also a recipient of Karnataka Government Suvarna Karnataka Rajyotsav Award in 2006. Sir has an honorary doctorate by Rani Chennamma University, Belagavi. Sir has also been awarded a Lifetime Achievement Award by the prestigious Indo-American Press Club, USA, in May 2022. And Sir has an honorary Doctor of Science by Thomas Jefferson University, Philadelphia, USA, in May 2022. He is the first Indian to receive this honor. Sir is a pioneering entrepreneur and has established Shiv Shakti Sugars in Raigad Taluk of Belagavi district. Sir, it is an immense pleasure to welcome you on the dais to address the participants.
Respected Honorable Atulji, Honorable Justice of Karnataka, Mr. Patil, Honorable Justice from Maharashtra, again Patil, Mr. Rete, dear students, and I'm really very happy. I don't want to take much time because we want to hear the Honorable Justice. So just I wanted to, because he knows about KLE. He was in Karnataka, Bangalore. So still just I wanted to introduce my society, sir. It's a 107 years old organization, started by 7 great teachers that time, and totally democratic setup. We have almost 9,000 members. Every 5 years we have election. That is also preferential voting system. And today we are running almost 296 colleges throughout Karnataka, Maharashtra, and Delhi, sir. Almost 1,38,000 students are studying my whole organization. And with education, we started health service also, which very important for rural places. And today, presently, almost we have more than 4,000 bedded hospital running in part of Karnataka, and last month we inaugurated 300 bed hospital in Pune also, sir. So we are crossing the now country now. In fact, we have a lot of research collaboration is happening last almost 20 years, sir. We have collaboration with the oldest medical university in US. Thomas Jefferson University is more than 200 years old. We have major partner as a research. In fact, we started India Center in Thomas Jefferson, where we wanted to make a Indian medicine system like Ayurveda, make it a popular in US also. And with this lot of research in engineering faculty also, and this society produce very good people in scientist, medical field, because we have 2 medical schools, and even politician. Sir, starting from Barrister Nath Pai, who is a socialist great person, is our student. He is passed from Belgaum Lingaraj College. Earlier, Dr. B. Shankaranand was a law minister, central law minister. He was our student. Present Chief Minister of Karnataka is again my student. And ex-Chief Minister of Mr. Jagdish Shettar is my student. And Prahlad Joshi, present, is a Minister for Parliament Affairs in Center, is our student. So we have produced very good. Anant Kumar, Mrs. Anant Kumar. They are all. More than that, the Infosys chairperson, Srimati Sudha Murthy, she was a student of my engineering college, where we have started in 1946 engineering college. After Pune, that is the second oldest engineering college. And presently, our Ayurvedic college is almost 92 years old, the Ayurvedic college. And we started not only in India to make Ayurveda popular medicine. We started in Switzerland also, sir. And Europe, we are looking for the Ayurvedic medicine, where is really is a high time to need this Indian medicine to become a popular in throat in India. So with this thing, sir, I am really very happy to with you. This even being in Karnataka very long time, I never met him personally, but today I am so happy. He has made a historical thing in Karnataka and judicially, and I am very happy. There are almost 60 teams are participating this, and we have 6 law colleges now, and one of the law college in Bangalore, sir, and there are law college in Hon'ble, Gadag, Belgaum, and Chikkodi also. I think every year about minimum 10 students, they become a judicial, like a justice and this thing. And with this, sir, I welcome once again this institution. I think this is the smallest campus in KLE society, sir. This is because, of course, Mumbai. So otherwise, my campuses are so big, minimum 100 acres, minimum 50 acres. Almost we have all the facilities, including sports and everything. Government of India has given us a center in Kelo India in Belgaum, and presently that is very important role. And with this few information about society, sir, and once again, thank you very much, sir. All you are here, and it made us too proud. Thank you.
It is an absolute honor to introduce the esteemed chief guest of today's valedictory session, Honorable Mr. Justice Abhay Srinivas Oka. Lordship did BSc and LLM from University of Bombay. Lordship got enrolled as an advocate on 28 June 1983 and started practicing in Thane District Court in the chamber of his father, Mr. Srinivas Oka. In 1985-86, Lordship joined the chamber of Honorable Shri V.P. Tipnis, a former judge of the Bombay High Court and former Lokayukt. Lordship appeared in several important matters and in public interest litigations and got elevated as additional judge of the Bombay High Court on 29th August 2003. Lordship got appointed as permanent judge from 12th November 2005. His Lordship took oath as the Chief Justice of High Court of Karnataka on 10th May 2019, and His Lordship took oath as Judge of Supreme Court of India on 31st August 2021. We all are eager to hear from you, Lordship. The session is over to you.
My esteemed brothers, Justice Rajesh Patil and Justice Vijay Kumar Patil, Dr. Prabhakar Kore, head of the institution, Dr. Vibhute, Principal J.M. Mallikarjunaya, Mr. Sridhar Prabhu, Professor Datta Gite, the members of the faculty of the college, and young friends who are present here in large numbers. This is the second time I am attending function of a law college of this society which comes from Karnataka. This society has Karnataka in its name, and therefore I can never say no to the function of any education institution of this society, because I can share with you that I always say that Karnataka is my second home, because I have spent beautiful years of my life there, about 2.5 years. In fact, I must record here that we had a function last year in Bangalore where 6 colleges of the same education society came together, and they started a very good initiative to encourage the law students to join judiciary And I was talking to Mr. Prabhu, who is instrumental in starting this drive. He said about 8 students were selected this year. So it's a great initiative by 6 colleges of this society. And this shows that they are contributing to the institution of judiciary. I saw the material which was given to me, the Sparkle National Law Festival. One is the material regarding National Moot Court Competition, and second is National Clan Counseling Competition. In fact, starting this competition, clan counseling competition, is something which is very, very innovative. I'll elaborate on that. Just brief reason is that it is the first part of art of advocacy. The advocacy starts from the moment your client enters your office. I want to tell, for the benefit of young students, that the most important, I am talking about those who are going to join litigation practice. And I still firmly believe that the litigation practice, that is the practice where you stand before the court and conduct the cases, that's the real legal practice, which has lot of thrill, and not only lot of thrill, but that is one profession where you can become instrument of change. You can help common man to get justice. Now, the first stage is very important when the client enters your office. The most important thing you have to learn is to allow the client to speak to you at some length. Because why a client comes to you? Because he feels that some injustice has been caused to him. Injustice has been done to him. He may be a client who may come to you because he is roped in as an accused, or he is a defendant in a suit, or he is a respondent in some appeal or petition filed in the High Court. So basically, every client will come to you because he feels that he has a case on merits, and he feels that justice is on his side. Now, unless you understand the client, unless you understand the client's grievances, you won't be able to function efficiently as a lawyer, because you must know what is your client's case. You must be able to pinpoint the grievance of your client, and ultimately talking to the client and what we call as taking instructions from the client is very, very important. It is very important that now in the change scenario you will get many women as clients. And I am so glad that during last 2 decades I have seen the changing face of the legal education, changing face of the legal profession. Now we have so many women joining the profession. In fact, I can share with you, I was talking to Brother Justice Rajesh Patil when we were on dais. I must share with you, during last 10 years, wherever I have presided over moot court competition, the winner is always a girl. Last 10 years I have seen this scenario. So it's very important that now so many girls are eager to join the profession. Because we have today also, 75 years after independence, we have still the women are suffering. Women of a particular category are suffering. So we need more women lawyers in the profession. And one more change which I have seen. I have been a faculty member of Maharashtra Judicial Academy, Karnataka Judicial Academy. I have gone to judicial academies of various states. Now the scene which we see during last 5 years is, at entry level of civil judges, more than 50% are women judges. And at entry level, if more than 50% women are joining the judiciary, maybe 20 years hereafter we'll have a scenario where judiciary will be also dominated by women. Now coming back to the topic of counseling the clients, I'll just give few examples, few hints to you. If a litigant comes to you because he wants to file a civil suit, let us take a simple case that there is a transaction, commercial transaction between client who comes to you and the person against whom he wants to claim relief. And that commercial transaction is covered by a document. Now, under the document, or there may be a series of documents, under the document, the proposed defendant owes some money to the plaintiff. That's what the client who comes to you feels. It's not only just taking the facts from the client and straight away call, stenographer, type yourself, prepare a plaint and file it in the court. You have to understand from the client that after the firstly you must find out who are the witnesses to the agreement. You must find out the correspondence between, maybe email which are exchanged or correspondence, to know whether the other side, the defendant, prospective defendant, whether he is admitting that he has executed documents. What is the suppose a legal notice has been already issued by the client demanding money from the prospective defendant, you must see what is the reply, what the defendant wants to say. It is only after understanding the merits of the case and the stand which is likely to be taken by the defendant that you can think of drafting a suit. It's not that easy. Suppose there are 3 agreements on which you want to rely upon. You have to ask the first question to the client that whether he will be able to prove these documents, because suppose there are attesting witnesses to the agreement and the defendant is denying that agreement. You must find out from your client whether those 2 attesting witnesses or one of them will support him. But maybe we do not know, the attesting witness may be siding with the defendant, and if you file a suit relying upon a particular agreement, and if you are not able to prove that agreement, then your client's case is likely to be defeated. So therefore you have to understand everything. It's not only, client tells you A, B, C, D, E, F, G, these are the factual aspects, then client wants you to claim a particular relief, therefore you should draft a plaint. You must marshal the facts, you must understand the documents, you must also visualize. You must also visualize what defense will be taken by the defendant. Whether defendant will have, I'll give you an example. Suppose defendant is likely to take defense that your suit is barred by a limitation. Then you should have those averments in the plaint. Imagining that defendant will take up this defense, so there will be pleadings. I remember as a junior lawyer, my father had told me that he had a friend who had retired from practice, but he used to guide the young lawyers. And my father's friend was absolutely taskmaster. He never tolerated even a mistake of comma or semicolon. So I went to him, I said, sir, I have received a very complicated case which my client wants me to draft a plaint. So I said, I want to engage you professionally, I will draft a plaint, you please settle it. Kind of imagination which that lawyer had, what he said was, he gave me a draft of the plaint. He made so many corrections in the draft prepared by me. I'm talking about 1983 or 84. Then he told me that, look, the defendant is likely to take following defenses. If defendant takes this particular defense, then you will have to apply for amendment of plaint. And even that draft he gave it to me. So it's not like client comes to you, you file something in the court. It's not like that. Take a case of criminal matter. Suppose your client is an accused in a case. Now don't be under impression that you will appear for him and in a very loud noise you will cross-examine the prosecution witnesses. You will threaten the prosecution witnesses and you will defend your client. That cannot be the approach. When a client comes to you who is an accused, you have to first ascertain from him what is his version, what has happened, what exactly has happened. If your client tells you, say case of a murder, client tells you that something which happened and in sudden rage, he took some, whatever was available and he assaulted that person. So what we call it a grave and sudden provocation under IPC. Then perhaps that will be your defense in a very difficult case. That it may not be offense under 302, it may be offense under 304 part 1 or 2. See, ultimately when a client comes to you who is an accused, you must understand what has happened and then you have to decide what is your defense. Whether you want to take defense that the client was out of mind, you want to take defense that client was under influence of alcohol. and what is going to be your defense, because on the basis of defense that you have to decide what is your line of cross-examination. So this is very important to take client into confidence when he comes to you, make him speak, because only if you allow the client or you ensure that the client speaks truth, you will be successful in profession. And one very important piece of advice which I want to give you, my senior in High Court gave me that advice, I followed it to the hilt. After you talk to your client, in the first meeting, never come to any conclusion. Ask the client to bring all the documents, or if he has brought all the documents, keep it with you. Go through the documents, think about it, make your own notes, and then call the client again for second discussion. Of course, unless there is very important, something which needs to be done immediately, somebody is encroaching upon your client's property, or you have to apply for an anticipatory bail, you can't afford to have this waiting period. But otherwise, you should do that. And I consider it as a foremost duty of every member of the bar to tell the client the truth. If after studying his case, if you come to a conclusion that he has no case, you should be frank enough to tell the client that, look, the law is against you. At least my experience was, I followed as a High Court practitioner, not even 10% clients went back, because they developed confidence in me. They said that here is a lawyer who is telling me that I have a weak case. Sometimes you will feel that your client has strongest case. Never ever give guarantee of success to the client. The reason is that after looking at the documents, or maybe if you are filing an appeal, looking at the judgment of the trial court, you feel that your client has best possible case. Never give guarantee, because ultimately the decision of the court depends upon interpretation of facts, interpretation of documents, and interpretation of law. Therefore, you may be having an impression that the client has best possible case. Never ever give guarantee to the client of success. As a short-term measure, you will feel that if you give guarantee, client will give you more money, or client will not go back, he will not go to any other lawyer. These are all short-term gains which will not survive for a long time. The reason is the most important reason which I want to tell you why you should not be giving guarantee. The reason is that you must remember that when you are member of a legal fraternity, you become lawyer, you are first officer of the court and thereafter mouthpiece of the client. I said a lot of things about preparation. I have seen Brother Justice Rajesh Patil appearing before me as a lawyer. He has argued some second appeals under Section 100. He was so meticulous in his preparation. He would know the latest judgments, he will tell me the facts, and he will stop at a right time. When I say that you have to be officer of the court first and then a mouthpiece of the client, within 2 years and 4 months tenure in Karnataka, I could see Justice Vijay Kumar Patil. He appeared for the government, and some of the lawyers who are there, Sridhar Prabhu is there, everybody will tell you, it is always difficult for any government advocate to appear before me. That is always challenging. But I found him to be officer of the court first. He would always tell me, sir, this is the file and this is the correct factual position. In some cases, he will say, sir, this is it, I can't improve upon it. But wherever he was satisfied that the state government had good case, he never gave up. Then he argued to the best of his abilities. The third lawyer who appeared before me is Mr. Sridhar Prabhu. He may have good professional practice, but what is more important is the kind of pro bono work he is doing for the Legal Services Authority. So these are fortunately 3 persons who are present here who always followed this rule. The rule is that you are first officer of the court and then mouthpiece of the client. What does it really means? I'll give an example. Suppose you are going to appear before the High Court in a case, and you find that there is a direct judgment of the Supreme Court or the same High Court which decides a particular law point against your client. See, it is always your duty as a lawyer when you start and tell the judge that, look, sir, obviously you will feel that this judgment covers case against me. You say that, sir, yes, prima facie it will appear that my case is covered against me by this judgment, and then make a best endeavor to distinguish that judgment on facts. Or in High Court, if it is a judgment of the coordinate bench, you can always say, sir, these are the points on which this judgment needs reconsideration. It can go to the higher court. And see why this fairness is required. Because ultimately, when I sit in the court as a judge, you appear before me as a lawyer, our object is same. Our object is that the litigant who is before the court must get justice in accordance with law. Ultimately, our concept of justice is justice in accordance with law. Many cases you will feel that, no, sir, great injustice has been done to my client. But ultimately, whether that injustice is covered by within four corners of law, if that injustice is covered by law, then of course your client must get a relief. So you must remember that you are integral. If you are going to be a lawyer, you are going to be integral part of justice delivery system. Unless the lawyers who appear before me are fair and well prepared, I won't be able to deliver justice properly. It is always said that you should not, some of the secrets of the trade. But one secret I want to share with you, because I am on fairness by the lawyers. I have been a judge almost for 20 years, so I can say that. Please remember one thing, when we sit in the court, we are quite lonely and alone. In the members of the bar, you are there, your colleagues are there, you meet lawyers in corridor, we are quite alone. And therefore, how mind of a judge works, I must tell you, a judge always likes a lawyer who is fair. Because if a fair lawyer appears before me, I have confidence that he will tell me the correct facts. So before I deliver judgment, I am not required to doubly check by reading the bulky file whether the facts stated are correct. And therefore, judges prefer lawyers who are really well prepared and who are very fair. And therefore, I began by saying that such a competition of client counseling is very, very important. Because this is again, as I said, part of the art of advocacy. Because I don't think, at least I have not come across any other college having this competition. Because you need to tell the students that when you are becoming part of the legal justice delivery system, it is your duty to counsel the client. Counseling is the right word. Why it is counseling? Because you must tell the truth to the client. You are not there to pamper the client. You must tell the truth. You must tell the client that, look, this is where your case stands. And this is the chance of you succeeding in the case. So it's counseling. So counseling is a very important term, you please remember. Then I come to the moot court. Moot court, of course, moot courts have come to stay. Whenever I go to college, I tell college or law schools in our country, I always say that you people belong to very privileged generation of students. I was student of historic government law college, perhaps the oldest law college in country, in 1980 to 1982. We never had more than one moot court competition throughout the year. We had not heard about this mock trial competitions or nothing. There was absolutely nothing. Except 2 or 3 lectures per day, there was nothing. And now, in all law colleges, law schools, you have all these competitions. You have mock trial competitions, so many competitions. Judgment writing competitions. I have delivered lectures by presiding over valedictory functions for the judgment writing competitions. You have guest lecturers. You have so many opportunities to learn. And therefore, you belong to a privileged generation of law students. I always say that. Because in those days, I just want to share with you my law college days. The government law college is very close to Churchgate station, if you must have seen that. And we are extremely benefited by presence of 3 or 4 very eminent institutions around government law college. One was, of course, Bombay High Court at a walking distance. We used to have only 2 or 3 lectures at that time. The second was, we had wonderful British Council library. And third and very important institution was Wankhede Stadium. And the fourth institution was Bombay Hockey Association Stadium. In those were the days, after our afternoon college was over, you used to go to Wankhede Stadium. purchase ticket worth 2 rupees and go to North Stand and see Gavaskar, Vishwanath, Vengsarkar, all giants in action. So, and whenever we were told that some stalwart is going to appear in Bombay High Court, we used to go to Bombay High Court. Not that we were able to understand anything about what was argued before the court. I have seen Sirwai in action as a student. I have seen Palkhiwala in action. So, the young generation, this new generation of students must take benefit of all these activities. Now coming to the moot court. Now, all of you, I want to tell you one thing. Moot court is extremely useful because that makes you study very hard, that makes you understand various concepts, legal concepts. But please remember that in moot court, what is tested is your ability to study, your ability to pick up new concepts, and your oratory skills. There is a vast difference between oratory skills and advocacy. Oratory skills are not necessarily going to make you a good advocate. Sometimes I am also amazed now, young lawyers appear before me. I remember one young lawyer appeared before me in Karnataka. Incidentally, as a judge of the Bombay High Court, I had given her first prize in one of the moot court competitions. So she appeared. At that time, she was second or third year student. You know, in moot court, what you do? You argue one point and then you tell the judges, if your lordships are satisfied with my first submission, I'll go to next submission. So the poor girl started doing that in court, so I had to ultimately tell her that, please, you remember, this is not a moot court, this is a regular court. If you start asking me question, if you are satisfied with first point, can I go to second point? My answer will be no, I am not satisfied with anything which you are doing. So please, moot court is of course very essential for your growth as a lawyer, but please do not carry yourself the way you are conducting yourself in the moot court. See, what is advocacy? Advocacy is not arguing in very loud noise. Advocacy is not doing something which you normally will do in theatres. Advocacy has many facets. Now, basic rule of advocacy I want to tell you, because I see some young, very bright students, I must say, who are very well versed with law. They don't know basics of advocacy. Now, one of the basic rules, if you are arguing before a high court judge, or for that matter, any court, one of the basic rules is that your eyes must be focused on the judge and nowhere else. Not on the left hand side, what your brother advocate is commenting, not on the right hand side. And the worst part is, you say something loudly in the court and look back. We want to see whether, clients are applauding. This is the worst kind of advocacy. Because ultimately, when you appear before the court and argue before a judge, it is your paramount duty to convince the judge. You are not speaking to the gallery, you are not satisfying. See, you may feel that because you argue very aggressively, the other litigants who are not your litigants, who are present in the court, they will get impressed. They will get impressed, I am not saying no. But if you argue in a manner which will only impress the litigants present in the court, it's a guarantee that you will lose your case. Because you are not bothered about your client. So, art of advocacy is very, very complicated thing. But it is not like any other art. For example, a painter or a singer, of course they have to do hard work, but that art has to be built in. But art of advocacy is the only art which we learn by practice. And it doesn't depend whether you are a second generation lawyer, third generation lawyer. Today, fortunately, both the learned judges who are here, they are all first generation lawyers. Still they are here as judges of two very prominent courts in India. So, ultimately, when we talk about advocacy, your duty is to convince the judge. Therefore, you must understand the mind of the judge. When you are going to appear before a judge, you must know what is the approach of the judge. You are handling case of, say, landlord and tenant. You must study how the approach of the judge is. Sometimes, if you study, you will realize that this judge has a pro-landlord tendency or pro-tenant tendency. If you are arguing a criminal matter, some judges are very, very strict and sensitive when it comes to offense against a woman. Therefore, you must study the judge. You must understand the inclinations of a judge, the way he functions. Some judge may not like very lengthy argument. Then you must see that you must understand that this judge does not like lengthy arguments. Therefore, you must moderate your own arguments. What happens in moot court is, you study the program in detail and you stand up in front of a mirror and there are preconceived arguments you write down. You practice yourself, you practice before your team members or your professor who guides you. So it is it's a preconceived argument. In court, preconceived argument never helps you. Preconceived argument never helps you because if there are 10 points in your client's favor, you have to start with one point which will appeal to the judge. That's very important. So please remember one thing, that your duty is to convince the judge and not to convince your opponent or litigants present in the court about your abilities. Sometimes silence is very important. I see now some young lawyers, very, very energetic. So when appeal is being heard for admission, when we judges show inclination, we are not going to admit this appeal, we are going to dismiss it. But young lawyer who appears for respondent starts getting up, sir, I have to say this, I have to say that. Now sometimes silence is important, because when you see that judge is taking your opponent to the task, the best policy is to keep quiet and just keep on reading the papers in front of you. Never show that you are enjoying because judge is taking your opponent to a task. Because if you start making gestures, start laughing because your opponent is being taken to the task, the judge will say, this man seems to be overconfident and he is enjoying at the expense of his colleague. Today it will be his colleague's turn, tomorrow it will be his turn. So as a judge, I may feel now I will call upon him. So therefore, silence in the court is very important. You should avoid temptation of saying so many things in the court. There is a new tendency now on the part of young lawyers. The new tendency is, if they find judge going against his case, sometimes they say something which they should not be saying in the court. Sometimes they will say, oh, my lords have already made up your mind. So what is the use of arguing? See, one case is going against you. If you fight with the judge like this, remember that you have to appear before the same judge over and over, days, years and years after. You can't do that. Ultimately, you have to take it gracefully. Because you are officer of the court, you do your best to convince the judge, but judge is not getting convinced. Never get agitated in the court. But that will be extremely harmful to you in the long run. See, advocacy is not only arguing before the court. I always believe that your real skill is tested when you cross-examine a witness, maybe in civil case, maybe in criminal case. That is the most difficult part of advocacy for any lawyer. When a witness is in the box, you have uphill task to perform, because you can't only browbeat the witness and start asking, oh, Mr. So-and-so, you have lied in the examination, chief. Such questions won't do. Or Mr. So-and-so, you shout at the witness and say, answer my question. That's not the question. When witness is in the box for cross-examination by you, you must be thinking on your feet and you must be ready with idea what exactly you want from that witness. In what manner that you want that witness to answer in the cross-examination, which will destroy the case of the client who has brought him there. So ultimately what is cross-examination? See, one object of the cross-examination is that the witness has lied, then elicit truth from him, or otherwise get answers from him which will ensure that the judge is satisfied that person is not giving truthful version. So the judge discards his evidence. And sometimes third is, you discredit the witness by pointing out that how he is inconsistent in his story or his version. So when witness is in the box, he is not a person on whom you will jump upon or you will attack him. Sometimes that is also required. That is also required. That sometimes some witnesses are difficult to crack, and therefore you have to be a little bit aggressive, but not with every witness. You have to see the witness before you really take him to the task. And one more thing you have to remember. I have done that mistake as a trial lawyer, therefore I am telling you. What happens is, as a young lawyer, you will go and you want to cross-examine a witness. You ask one question to the witness in cross-examination, just say, no, I am not going to allow this question. This is completely irrelevant. Don't ask this question. Then as a junior lawyer, we tend to fight with the judge. No, sir, this is most relevant question. You must allow this, or you give reasons for disallowing this question. Never ever do that. Simple, ultimately you must understand one thing, that a judge is also a human being. And therefore, if one question is disallowed, very respectfully say, sir, I agree, I'll go to the next question. Ask about 10 questions, and then if everything is quiet, ask the first question which was refused in a different word, different form. In 80% of cases, judge will allow it. But if you fight with the judge, then he will pass a long order, look, for A, B, C reason, this question is irrelevant. And therefore, that you are precluded from asking that question. Therefore, these are the things, how we are going to learn these things. Somebody will ask me this question. No senior, no law teacher is going to teach you art of advocacy. That art of advocacy can be learned only in one school, and that school is court of law. Even today also, if you want to practice in the court, whenever you have time, whichever is the court close to a place where you stay, go there and observe the proceedings. Go to a civil justice court, go to magistrate's court, go to any court, but sit in the court, observe how the court functions, observe how the judge reacts, observe how a very senior lawyer reacts. You have to learn so many things. I remember when I started practicing, I practiced in district court for 3 years. So one of my very distinguished friends, a very, very prominent civil lawyer now on the trial side. One fine morning, a litigant came to him, and it was a case under section 307 of IPC. So client said that you must defend me. He was on bail. My friend was extremely thrilled. He had put in 1 year's practice. I had put in 6 months practice. So he came to me. He said that, look, I have a new case, that also 307. Later on, of course, we realized that 307 case is a great challenge, because there the injured witness is there to depose before the court. It's a very difficult case for a defense lawyer. So my friend was elated. He came to me. My father was a district court lawyer. We had good library. So he used to sit with me till 12 o'clock, 1 o'clock in the morning, and he used to keep on imagining what the prosecution witness will say and what will be the cross-examination. And ultimately, when trial started, the complainant was the first witness. Complainant did not support prosecution. He was declared a hostile. And we were so raw that, he was perspiring, my friend. He said, I don't know whether I should cross-examine this witness. He was declared as hostile, but he felt that he is engaged as a lawyer. If he doesn't cross-examine the witness, what will happen? So he said, now you go to bar room and find out some senior lawyer, ask him. So I went to a senior lawyer, very distinguished lawyer on the criminal side. Of course, he was not known for using very decent language even while talking to the colleagues. So I explained to him, sir, this has happened, what should we do? So he said something to me in different language, but I politely conveyed to my friend. He says that do nothing, sit down, no cross. Tell the judge, no cross. These are the things you will not learn from law books, that what is to be done if it is your first case, a criminal trial, you are defending the accused. What is to be done if witness is declared as hostile? This you will learn only by attending the court. So that is the best school. I know that when you join the legal profession, There are a lot of gossiping which takes place in the corridor. There is something which you enjoy. Of course, I also enjoyed it as a lawyer. But in initial days, instead of enjoying that gossip, please remain seated in some court so that you can learn everything. So therefore, though you may be very successful in your moot court competition, and that is really going to help you in your profession, I am not saying no, because you study so hard. I have seen now some young students appearing in moot court competition. They prepare very thoroughly, they know all the precedents on the subject, and they have good oratory skills. Other day I presided over a moot court competition. One girl was, fantastic oratory skills. And I inquired with her while giving her prize. She was a third year student. And I asked the girl what she interested in. She said, no, I want to practice in Supreme Court. So I told her that I am glad that by the time you join bar, I will be retiring. Fiercely competitive. I thought that if this girl appears every day and start arguing on law, what will happen? So these competitions will help you a great extent. But please remember that when you enter court, it's a different ball game, as we call it in cricketing terms. It's a totally different game where you have to learn from the scratch. Last thing before I close, today I always tell this to the law teachers. Of course, I must say that this subject today is exceptional for the moot court. It is going to really test not only the knowledge of law, but the students will have to think about what is prevailing in our society, what is prevailing in the world in which we live at grassroots level. But I have strong reservations. Sometimes I tell the principals of the colleges that why we have this fashion of having a subject on public international law, arbitration, commercial law in moot court. Today is of course exception. I mean, this is a really challenging subject. But I always feel that if you want to really train the students and their mind, what you should do is pick up a paper book of a criminal appeal from the High Court or a civil appeal. Criminal appeal where there are a number of witnesses, where there is a, say, confession, there is issue regarding recovery of weapons. Modify it and give it to the students. Or where a civil suit where the issue is whether a document is a sale or it's a conditional mortgage, where it's a conditional sale or mortgage. Give them paper books so the students will know how to read the pleadings. Students will know how to read the charge sheet. Students will know how to interpret a document. Students will know how to appreciate the oral and document evidence on record. So that's the practice which all law colleges should be starting. And finally, to the students, there's always a talk now that I interact with the students. I was associated with 2 or 3 law schools. Today also I am associated with MNLU Aurangabad. I go there, I interact with the students. So some students say, sir, I want to do something in commercial law. I want to do something in IPR. I want to do something in arbitration. Or everybody is, now some kind of a craze is there. I want to do something on the commercial side. Actually, there is nothing like commercial side in law. It's law ultimately. It's a litigation. Though our legislatures have chosen to describe certain category of litigation as commercial litigation, in fact, my personal view is that there can't be any commerce associated with litigation. But I am telling you that this arbitration, commercial matters, IPR, this constitutes only 2, 3, 4% of our total litigation. And today, if you want to, of course, we need good corporate lawyers. We need very expert lawyers who appear in IPR matters. But if you want to really serve the legal system, the justice delivery system, you can play a role, really effective role, if you practice in traditional courts and not practice as a private lawyer. We need good government lawyers. We need good prosecutors. We talk about unmerited acquittals. You must have read that, because we don't get competent prosecutors. So the real challenge lies in these traditional courts, where you will be really tested. So don't get fascinated by these commercial matters or this IPR. You must think of these traditional courts, where that is where you will be tested. And look at the scenario, look at our freedom fighters. There are many freedom fighters who were top class lawyers in our trial and district courts, and look at their stature. So therefore, don't have this kind of a thing that only commercial litigation is superior. And last thing about career. Many young students come to me, they say, sir, how I'll get opportunity to practice in the High Court? I don't want to practice in Taluka Court. I don't want to practice in District Court. Somebody says, no, I want to come to Supreme Court. Now, we have a system where everybody can't come, everybody can't start practicing in High Court, everybody can't come to the Supreme Court. I'm not going to tell you. You may have your own aptitude to practice somewhere. What I want to tell you is, practice before our trial courts, maybe Taluka Court or District Court, is no inferior from practice in constitutional courts. Believe me, those lawyers who practice in our trial courts do more responsible work than lawyer like me who appeared in High Court do. Because ultimately you are the one who draft the pleadings for the client. You are the one, if you are appearing on the criminal side, you draft a complaint for the client. If you are a defense lawyer, you are the one who decide what should be the line of defense. So those who appear in trial courts, firstly they deal with common man's issue, and you actually decide what will be the fate of the client. Because if you don't have proper pleadings, if you don't have proper evidence recorded, what as a High Court lawyer I am going to do in higher court? I'll be helpless. So the job of lawyers practicing in trial and district courts is as important and as valuable as job of a lawyer who appears in High Court or Supreme Court. So never ever have this inferiority complex, I am only a trial court lawyer. No, you should say proudly that I am a trial court lawyer, because you are the one who are dealing with the client directly. So please remove this impression in mind that practice in constitutional courts is superior than practice in our trial courts. The reason is everybody can't afford to come to the High Court or Supreme Court. That's the system in which we live. But never ever say this to your own self also that, I am in trial court, I am some kind of inferior lawyer. No, you are doing the same job which lawyers in higher constitutional courts are doing. Only difference will be the pay structure will be different. But of course now I have seen some trial courts also, pay structure has improved. Mr. Prabhu is right. So I end now. You have been here, 60 teams are here for last 3 or 4 days. All of you must be now thinking of going back to your respective places. But I am sure that you will go back very enriched with this experience of these 2 competitions. I am sure that you must have made friends because there are so many teams of different colleges. I believe 9 states. Teams were from 9 states. So you must have made new friends. And so it's must be a learning experience for you. So I wish a great success to all of you. In future, whichever field you enter, I wish a great success. And as usual, when I go to any law college, I will appeal to you, appeal to at least some of you, please think of joining judiciary. Thank you very much.
Thank you, sir, for your kind words and your guidance. I'm sure all of us have learned something today. Now, everybody has been waiting for this moment. All the participants, are you ready? Are you? It's finally time for the prize announcement. For that, I would like to call on the dais our faculty Julie ma'am and Bipasha ma'am for the announcement of results.
A very good afternoon to all of you. Good afternoon to the honorable dignitaries on the dais and to all the participants from across the country over their presence at the 4th National Law Fest Sparkle 4.0. After such enlightening speeches by our honorable dignitaries, we all have
Thank you, sir. Now we move to the award for Best Counselor. It goes to Team Code 24, NCC 24. We have a tie between Nandini Sura and Vatsal Batra from NIMS Kirti P. Mehta Law School. Kindly approach the dais. Best Student Advocate for National Moot Court Competition goes to Priya Bohra from VES College. I would now request Honorable Justice Mr. Vijay Kumar Patil sir to present certificates to our winners. Next in sequence, for the best memorial, the award goes to NMCC 16 KL University. I would request Honorable Justice Mr. Rajesh S. Patil sir to present the certificate to the team. I would request Priyanka Bohra from VES College to approach the dais. She's been presented with the Best Student Advocate. I would request Honorable Justice Mr. Vijay Kumar Patil sir to present the certificate. Thank you, sir.
Now, the movement of the event. I'm going to announce the runner-ups and winners of client counseling first, thereafter, moot court. The runner-ups first. The runner-ups for the National Client Counseling. NMCC 25, Christ University, Lavasa. And the winners for National Client Counseling, team code NNCC 24, NM IMS Keith P. Mehta, School of Law. Participants, please approach the dais. Now I would request Honorable Justice Mr. Abhay S.Oka sir and all the other dignitaries to present the certificate and trophies to the participants.
We now call upon the runners-up of the National Client Counseling Competition, UILS Law College, Chandigarh.
The runner-ups for the National Moot Court Competition goes to NMCC 25 Christ University, Lavasa. And the winner for Moot Court Competition goes to And now, the winners for Moot Court Competition goes to NMCC 13, Rizvi Law College, Mumbai. I would request Thank you, everyone.
And on that happy note, I would now call on the dais our Honorable Principal Sir to deliver the vote of thanks. So,
good afternoon to the dignitaries on dais, teachers, students and all the participants. I know, this is the hardest part. Nobody wants to listen to me now because everybody wants to go. And that's the reality and truth. Once the prize declaration is over, that's all. But however, I am here to complete a formality, and formality has to be completed in best possible manner. Having said that, I would like to thank Justice Abhay S.Oka, Judge Supreme Court. Sir, we were following you. I mean, sir is related and connected to academics. He was Chancellor for Maharashtra National Law University, and he is now Chancellor to Aurangabad Maharashtra National Law University. And then sir is also heading one of the institutes, that is International Research Law University at Goa. So, though sir is a judge of Supreme Court, but his bent of mind is towards academics and development of the academics. So he belongs to our fraternity, I must say, and I am proud of that. And anyway, sir, I have to say that because, anyways, we would like to establish a connection with a justice who is from the Supreme Court, and who does not want to have a connection with justice of a Supreme Court. So there is, thank you so much, sir, for sparing your valuable time and coming here and delivering an address to our students, whereby minutely you have dealt with all the aspects of client counseling as well as moot court. And definitely the takeaway for the students of KLE institution as well as participants is so great. It is enrichment in their knowledge and wisdom, that if even they follow the few things of whatever you have said, is definitely going to make a change in their career. It is for sure. Now I would like to thank Justice Rajesh S. Patil, Bombay High Court Judge. Thank you, sir. Sir was also a teacher in New Law College over a period of a time, and sir is also connected with academics. And I went to sir's chamber. I mean, I was astonished the greetings which we got as academicians. I mean, sir actually spoke with us for almost 45 minutes. He paid, and he said, I would like to talk to the students of KLE and other participants as well. So his enthusiasm has definitely helped us, and you have heard him in the afternoon as well. Thank you. Thank you so much, sir, for giving your valuable time and coming to KLE Society. Now I would like to thank Justice Vijay Kumar Patil, Karnataka High Court. I spoke, sir, over a phone, and at that point of a time, few of my colleagues from KLE Law College, Bangalore, have visited his office, and he told, you have called and your colleagues are here. And such a warmth he has shown, and he said, don't you worry, you need not to follow all these formalities, and I am going to be there for this. And thank you so much, sir, for your august presence in this gathering. Professor Dr. Kushal Vibhute, sir, was the Dean of Pune University as well as Amity University. He has spent his 40 years in academics. Sir, thank you so much for gracing this occasion and judging the final round. Now, I'd like to thank my chairman, a chairman of KLE Society, Dr. Prabhakar Kore. I mean, sir is a visionary. Not only that, but whenever he comes here, he tells only one thing to all the law teachers and myself, that we don't want KLE Societies, KLE Law College to be any other college in this institution. And he tells to conduct the competitions. There are two kinds of management. One, they think about the revenue generation, and one management which thinks about to give back to the society. So he always tells us, we have to give back to the society. And you can give back to the society in a way by conducting these competitions and sharing the knowledge. Sharing is caring is his motto. Thank you, sir. Thank you for giving us opportunity. I would also like to thank Dr. J. Mallikarjunaya, Principal, KLE Law College, Bangalore. As the saying goes, a journey of 1,000 miles begins with a single step, and I must tell you, he was with us with every single step, taking care of minute intricacies and calling me, asking me, is everything all right? Do you require any help from me? And there was a conversation almost every day. Thank you, sir. Thank you for helping us. I would also like to thank Mr. Ganesh Kumar and teachers of Junior College, Dr. Ghansham Giri, Mr. Deepesh Pillai, Manager KLE Institution. Now I would like to thank the staff, teaching staff and non-teaching staff of KLE College of Law, They were working so hard, tirelessly for last 3 months to make this competition so successful. The wheels have started rolling long back, and I must tell you, I was little bit harsh on them, and I must say it on record that since last 2 Sundays, they were here working for this competition. So thank you so much for your help to make this program a grand success. Definitely, volunteers are the warriors. Students are the warriors of these competitions. We have 70 odd volunteers who were helping us right from any moment. Whatever we have told them, they have done it in the best possible manner. Thank you so much for all the KLE students and volunteers. Last but not the least, definitely the show is for all the participants across the country. 60 teams have participated in this moot court competition and client counseling competition across 9 states, and you were fabulous, wonderful, without troubling us. You have been so disciplined. Thank you so much. Thank you so much for that. Now I must stop here because as the saying goes, in one of the religious texts of Jnaneshwari, it says that you cannot show a lamp to the sun. So already when we have got such an enrichment of a knowledge from justices, we should stop here. But before that, I would like to make one announcement that we are coming up with National Trial Advocacy Competition on 5th and 6th August of 2023, and we would be releasing the brochure in couple of days. So our work has started. Though we have completed this journey, but we are starting with the new journey for that particular competition, whereby students across the country will participate in that. And I would like to request all the participants who have participated in this competition to kindly register for the trial advocacy competition as well, because whereby you would be dealing with intricacies of examination in chief, cross-examination. So there is lot to learn from a trial advocacy as well. Thank you so much. Thank you one and all. Have a great day.